Hello everyone, welcome to weekly Magnum Current Affairs of PMF IAS. Now we have started this series of weekly Magnum Current Affairs where we will discuss important news appearing in different sections. For example, let's say Polity, which I'll take, Economy taken by Jatin sir, Environment and Science and Technology taken by Akshay sir. And the idea is that we give you important news which has appeared in a week and which is relevant from your exam point of view, either prelims or mains. Right, so this is the idea behind which or based on which we have started this series, and it will be a weekly series. Okay, so let's start our discussion for the section of polity and governance, and our sources are generally the Hindu newspaper and the Indian Express along with PIB or other sources for different sections or different modules. So in today's discussion I have taken these important news, as you can see: serving justices but not justice, understanding in-house impeachment process. So there are two things, just understand this. There is an impeachment process, that is a process to remove the judge, impeachment process to remove the judge, which is provided in the Constitution of India, removing the judge of Supreme Court and High Court, provided under the Constitution of India. Okay, and also under Judges Inquiry Act, and the other is in-house investigation process. Now that is very different. In-house investigation process is a closed process, and this is what the author in that particular article appearing in the Hindu newspaper has explained, that because the investigation process, which is different from an impeachment process, is a very opaque and a closed door process taking place, hence it violates principles of natural justice. This is what has been highlighted. Hence we need to understand the elements of principles of natural justice as well. Fair share of divisible pool of tax collection. Here basically in essence the idea is that the editorial appearing in today's Hindu newspaper highlights that states have demanded that their share of central pool of divisible tax is decreasing, or their share of sources of revenue taken from the center is decreasing, and hence they have demanded to increase the central pool of horizontal devolution from 41% to 50%. So that is something which we need to understand from a constitutional perspective, not from an economy perspective. We need to understand from a constitutional perspective, particularly with respect to the role of Finance Commission. Then this news, ECI upgrades non-statutory index cards. Basically, Election Commission of India has provided a sort of a non-statutory report whereby it provides collection of data by enhancing digital technology and makes the process much more easier. So this news is more from a prelims perspective, and then this news, how India conducts its census explained, appearing in the explained section of Indian Express. Now see, this news, I'm sure you will keep on reading news, this particular news every now and then in the newspapers, but two things are important with respect to conduct of census for 2027. These two things are, I'll write in a different color. These two things are, first, post 2026 delimitation will take place. Post 2026 delimitation will take place, and hence conduct of census becomes important because parliamentary constituencies needs to be delimited according to the Constitution of India. And second, reservation for women in Lok Sabha and State Legislative Assembly, including Legislative Assembly of National Capital Territory of Delhi, along with further reservation. Now this aspect has been provided under Constitution 106th Amendment. So how is census related to all of this? This is something which we need to understand also, because a question was asked in your prelims of 2024. So these are some of the news. Let's understand from an exam oriented approach. So see, the idea is not just to read the newspaper but also to extract what is important for us, because yes, articles appear in the newspaper but they're not exactly written for UPSC. We need to extract those information which is relevant for us. And on this note, let's start our discussion from with respect to our first topic, serving justices but not justice. So it says, while the stated reason for lack of external oversight under the in-house procedure is to preserve judicial independence, it cannot shield the institution from public accountability. Now see, the author in this article has raised very important point. The author has highlighted, just understand this part. The author has said, see, when you conduct your investigation process, which is an in-house investigation process. Now when we say in-house, obviously it means it will be conducted by the judges of Supreme Court and High Court themselves. So basically the judges conducting an investigation against fellow judges of High Court and Supreme Court. In a way, that is a violation of principles of natural justice. So the author is saying that when you conduct in-house investigation, that too in a closed manner, and you also do not publish the report, then the point is that yes, you say that this is important for judicial independence, that is fine, no issues with that. But what about right to information? What about various principles of natural justice? What about public accountability? What about transparency in the entire process? All these goes for a toss just in the sake of judicial independence. So the author has highlighted this issue, and this issue is actually very important because I'm sure a lot of articles will appear on this point, that when we talk about this in-house procedure, you say that this is a closed door procedure and this is to protect judicial independence. But is the cost of which we are paying, or which the society pays, in terms of not knowing the report, not knowing the process, no legal representation allowed to complainants? So in a way, is judicial independence proving costly, and is it affecting the basics of democratic functioning of any society? This is what the author in essence, in crux, has highlighted. So this is one thing which we need to understand, that is in-house investigation process goes against the principles of fairness or principles of natural justice. First thing, so this is whether this goes against principles of natural justice just to protect judicial independence. First one, two extreme situation. And the second thing is that you need to understand the difference between, of course, the impeachment process which is provided, or you can say the removal process for judges of Supreme Court and High Court judges, which is provided under the Constitution, and also the Judges Inquiry Act. How it is any different? These are two different things, just know this. And a question was asked on this part so far, but since Justice Sanjeev Verma's already in-house procedure has been conducted, their investigation, and it's likely that Parliament may initiate an impeachment process in the upcoming session. That's why this topic becomes crucial. It's possible that in an upcoming mains examination in 2025 itself, this question could be asked. You never know. So these are the two parameters which we need to understand in this particular topic, and this is basically a mains oriented topic. So if we talk about the syllabus, then you see basically functioning, structure and organization of judiciary. And based on whatever we have discussed, I've taken just this as your practice question for mains, because this gives you an idea that why I have taken this particular topic. And the practice question says, and based on this practice question, this is how our discussion will follow also, that the in-house procedure for inquiry and investigation against judges of constitutional courts, although ensures judicial independence, but comes at the cost of principles of natural justice and the right to information. Critically examine the statement based on past precedents. So you have to highlight certain past precedents, and based on that you have to explain that whether this in-house procedure to safeguard or to preserve judicial independence, does it comes at a cost, and is that cost too high for the society to pay? That is the point which this article has raised. So this is an analytical article, and hence we need to understand all aspects. But first, this is Article 124, Clause 4 of the Constitution of India, which provides for elaborate process for removal of a judge. and it says that judge of a Supreme Court shall not be removed from his office except by an order of the President passed after an address by each house of the Parliament supported by a majority of total membership of that house and by a majority of not less than 2/3 of the members of that house present and voting. Okay, so this is the type of majority required to impeach or remove a judge. I'm saying the word impeach, although not mentioned in the Constitution, because this is what UPSC asked in your prelims examination of 2019. And clause 5, article 124 clause 5 says that Parliament may by law regulate what? First, the procedure for presentation of an address and for investigation and proof of misbehavior or incapacity of judge under clause 4. But nowhere this term, which is to be proved, proof of misbehavior or incapacity, these words are not explained, are not defined in the Constitution itself. So this is what has been provided under the Constitution of India regarding impeachment process. And since it says Parliament may by law regulate the procedure, and accordingly Parliament has enacted the Judges Inquiry Act to regulate the entire procedure. Now just to go a certain detail, in slight detail, see actually what happens is that this process of inquiry has to be initiated, could be initiated either in Lok Sabha or in Raj Sabha. Now this is I am talking about with respect to article 124 clause 5 plus Judges Inquiry Act. Judges Inquiry Act. In Lok Sabha, at least 100 members must propose or sign this resolution, 100 members or more. And in Raj Sabha, 50 members or more. 50 members or more must sign this resolution to initiate process of removal of a judge of a High Court or Supreme Court. And if this initiates in Lok Sabha, then it is to be submitted to the Speaker. And if it initiates in Raj Sabha, it is to be submitted to the Chairman. Now, it is up to the Chairman whether to initiate it further or not. So they can either initiate the process further and then conduct an investigation committee, or they can refuse the proposal. Hence, it is the discretionary power both of Chairman and the Speaker of Lok Sabha. So both the Speaker of Lok Sabha and the Chairman can either accept or reject this proposal. So if they accept, again investigation committee is to be constituted, comprising of judges and also one eminent jurist, and then they will conduct the entire investigation. A judge will be called, the concerned judge will be called to submit his opinion, and this investigation committee will have powers of civil court. So this is an elaborate procedure again provided under Judges Inquiry Act. But this is very different from in-house investigation procedure, which more or less is opaque, and hence the author has suggested that in-house procedure, different from this impeachment procedure, violates principles of natural justice. Again, a view taken by the author. Let's see whether this view taken by the author is correct or not. But why I have told you this about this thing in entire detail, because the question was asked in your prelims examination. Let's go through this question, because that's the whole idea of this discussion of current affairs weekly current affairs, Magnum Weekly Current Affairs, because a news is important not only because of its relevant context, but also because a question has been asked from a related topic in the past, and those questions needs to be understood also from their contextual relations. So this question says, consider the following statements. Motion to impeach a judge of the Supreme Court of India cannot be rejected by Speaker of the Lok Sabha as per the Judges Inquiry Act. Wrong. It can be rejected by the Speaker of Lok Sabha or even the Chairman of Raj Sabha, or by both. Second, the Constitution of India defines and gives details of what constitutes incapacity. No, it does not define or give details. It simply says proof of misbehavior or incapacity. These are the two grounds on which investigation will be carried by the investigation committee under the Judges Inquiry Act. Third, details of the process of impeachment of the judges of Supreme Court of India are given in the Judges Inquiry Act. Yes. See, so very clearly questions have been asked on Judges Inquiry Act. And then the whole process of majority. If the motion of the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of total membership of that house and by not less than 2/3 of the total members of that house present and voting. Yes, this is also correct. So 3 and 4 are correct. Which of the statements given above are correct? Correct answer 3 and 4 only. So you see, this topic in that way becomes important, and it's possible that in near future an article may also appear in the newspaper, and then you will have a better understanding of the difference between impeachment process and in-house procedure. So after understanding the impeachment process, let's talk about the in-house procedure. And here it's important to understand first of all the principles of natural justice. Why? Because it has been highlighted that the in-house procedure, let's go through the in-house procedure. It says no outside agencies are involved and only the judges themselves investigate against brother judges. So it says allegations against any judges of High Court or Supreme Court shall be examined by their peers and not by an outside agency in order to maintain judicial independence. So the question is that, is this costing too much? Is the cost too high? Next, constitution of 3-member committee if case holds merit, comprising of Supreme Court judges and shall hold inquiry into the allegations. Fine. Nature of inquiry to be a fact-finding inquiry and not a judicial inquiry, where the judge concerned will be entitled to appear and have their say. And such an inquiry will not be a judicial inquiry involving examination and cross-examination of witness and representation by lawyers. So they cannot, so let's say there is a complainant, which actually happened in the case of former Chief Justice of India, Justice Gogoi. She complained of sexual harassment. Now, she could not be represented through a lawyer because the in-house investigation process barred her or prohibited her from doing so. The question which is raised is, does this violate principles of natural justice? On this note, let's understand about principles of natural justice. So, see, principles of natural justice comprises rule against bias. Means, if someone is biased, how can we say that that person will give a fair judgment? Suppose I am biased, let's say in favor of the judiciary. So how can I give a fair judgment, or if anyone is biased? And this is the legal principle. I've highlighted this for law students. Rule of fair hearing means each side should be given a fair opportunity. It also means no side shall be condemned unheard. No side shall be condemned unheard. Every side should be given an opportunity, and judges should not pass orders without hearing the other party, because then again that will also be considered as bias. Then procedural fairness. The process must be fair. When we talk about fair, it means that whatever the procedures you are following, it must not violate principles of natural justice along with fundamental rights, including Article 14. And also, it should not be arbitrary. It should not be arbitrary, because Article 14 and arbitrariness are antithesis to one another. Another statement which can be asked in your mains examination. Publication of judgment. This is also another important. Just assume that whatever judgments we study through newspapers or through articles, through journals, let's say the Supreme Court or the High Court never published their judgment. How will we know then what are our fundamental rights? How will we know then what the Supreme Court has given there? What have they decided? So publication of judgment is a very important procedural aspects of natural justice, and it implies the element of fairness, and also is an aspect of reasoned decision. Means the decisions must be based on evidence, must be based on facts, and must be based on reasons. Shouldn't be unreasonable, shouldn't be arbitrary, shouldn't be discretionary, right? So it says these more or less are the core principles of natural justice which must be observed by quasi-judicial and administrative bodies while taking decisions. Quasi-judicial bodies are tribunals or such bodies which adjudicate disputes, decide upon disputes. For example, SEBI, Securities Exchange and Exchange Board of India, CCI, these are adjudicatory bodies or the tribunals constituted by these bodies. Okay. And some past precedents are, first of all, let's go through the past precedents. So the author has made these allegations against judges of High Court and Supreme Court and suggested that in the past many complaints have been filed against a lot of judges. But because this in-house investigation process is very opaque and very indoor process conducted by judges themselves, hence it violates principles of natural justice. And this overall goes against the spirit of democracy, goes against accountability, goes against transparency, and goes against procedural fairness, because even the reports are not published. So some of the some of these instances are the Chief Minister of Andhra Pradesh leveled allegations against Justice Ramana and other judges of Andhra High Courts, and complained against Justice Maheshwari as well, who was transferred from Andhra High Court but presently is the judge of Supreme Court. So again, the question is, if there are any, let's say someone has allegated or said something or allegated certain charges against any of the judges. Now it should be investigated, whether it's true or false. All of that, truth or falsity of it, should come out in the public. Allegations of sexual harassment against former CJI Ranjan Gogoi in 2019, it says, this is where it gets disturbing. The complainant was neither allowed legal representation through a lawyer nor was submitted a copy of the report, because in an in-house investigation, investigation procedure, none of them are allowed. And that's why it is alleged that it goes against procedural fairness. It goes against principles of natural justice. Rather, an inquiry was instituted against the complainant as her allegations was considered to be part of larger conspiracy for an attack against judicial independence. So again, these were allegations made. Further, Justice Suryakant, who is to become the next CJI in November 2025, also faced serious allegations when he was judge of Punjab and Haryana High Court, and he was also accused of taking bribes for bail orders, illegal acquisition of assets, corruption and casteism in selection of subordinate judicial officers. And Justice A.K. Goel also raised these concerns to the former Chief Justice of India, but again nothing happened. This is what the author is saying, that there are a lot of allegations of corruptions and wrongdoings against judges, but because of this closed door in-house investigation process, nothing substantial has happened in any of these cases. And based on this, the author has suggested that he has criticized this in-house investigation process on the grounds that it violates principles of natural justice and also right to information. Why? Because it is a vital aspect of participatory democracy and rule of law, also an important facet of right to freedom under Article 19(1)(a). Judicial independence cannot come at the cost of judicial opaqueness. This is what the author is suggesting, that if you want judicial independence, then there should be transparency, not opaqueness. And publication of report would serve as a vital safeguard against arbitrariness, because if you do not publish your report, then how would anyone understand that what actually went behind closed doors? To ensure greater public accountability and transparency, if the process is transparent, if the process is fair, if there is publication of report, all of this will foster public trust in institutions important and as vital as the judiciary itself. So this is what the author overall has criticized with respect to the in-house closed door investigation process. Now, if we look into this case, see, this was a prelims question asked in 2023. This was a prelims question asked in 2023. The question is, in essence, this word is very important. In essence, what does due process of law means? Options were, just look at the options very carefully. Principle of natural justice, procedure established by law, fair application of law and equality before law. This Article 14, procedure established by law, Article 21, fair application of law, you can say a very simple understanding, but since it's talking about in essence due process of law. Now in India, now we follow both procedural and substantial due process. That is, due process should be not only with respect to substantial provisions but also procedures, hence procedural fairness. So when we talk about in essence, then in essence due process of law refers to, I'll highlight in a different color, principles of natural justice. So you see, principle of natural justice so far has been asked in your prelims, could be asked in your mains. So hence you need to know about this particular concept. Now the question is that what will happen if this, let's say, investigation committee submits its report. This investigation committee, which was constituted for the case of Justice Sanjeev Verma, in whose house pile of cash were found after some fire took place. So it says the committee can devise their own rules and process consistent with principles of natural justice, but this is what the author is saying, that the process goes against it. Anyways, based on the inquiry, the committee can file three kinds of reports. First, that there is no substance in the allegations and hence the judges go free, no problem. That there is sufficient substance in the allegation of misconduct and such substance is so serious to initiate proceedings for removal of the judge. In this case, the procedure or Article 124 Clause 4 and Judges Inquiry Act will be activated. And that's why when this instance of cash was found in the house of Justice Sanjeev Verma, then it says that Chief Justice Sanjeev Khanna back then constituted 3-member committee to investigate the allegations against Justice Yashwant Verma of Delhi High Court, because a fire had broken out in his premises and pile of cash were found. The members of the inquiry committee were Chief Justice of Punjab and Haryana High Court, Chief Justice of Himachal Pradesh High Court and a judge of Karnataka High Court. So judges of high courts investigating against fellow judge of Delhi High Court. This is what the author has suggested, that this is against principles of natural justice. A man or a person shall not be a judge in their own cause. So this is the essence of this particular article, and I am sure based on this discussion you will be able to attempt the practice question which we discussed or which we started with. But let's go through it again. I'll read it again for your convenience. The in-house procedure for inquiry and investigation against judges of constitutional courts, although ensures judicial independence, but comes at the cost of principles of natural justice and right to information. Critically examine the statement based on past precedents. So I hope through this discussion you will be able to attempt this particular question. Moving further to another important topic. Okay, a fair share of divisible pool of tax collections. Retaining the 41% share in the divisible pool for states will be unjust, and this gets covered under GS2, particularly with respect to devolution of powers and finance up to local levels and challenges therein. Now please understand this topic overall. When we talk about center-state relationship, then there are three aspects of center-state relationships, also what we call as cooperative federalism. First aspect is legislative aspect, legislative relations provided under union list, state list and concurrent list. Then we have administrative relations, again provided in the constitutional provisions, whereby the union can give directions to state. Union can give directions to state. And then we have financial relations. Financial relations. where there is allocation of resources and also taxing powers, levying of taxes between center and states, right? So this particular part deals with, first of all, the third part, financial aspect. Now here what the states are saying, that now talks about horizontal devolution from center, that is center giving share of revenue to different states, and this is at 41% based on previous finance commission, or 42%. States are saying ki see, center is charging, or center's revenue through cess and surcharge. This allocation has increased, and since this is not shared with the states, cess is not shared with the states, hence states' own resources of revenue are decreasing. Secondly, post GST regime, states' revenue have decreased. States' revenue have decreased, right? And hence they are saying that please give us more give us more allocation of resources. The question is, who decides this? Who will decide that this much is what the state will have? This is decided by a constitutional body known as Finance Commission, constituted under Article 280, right? This is what the article talks about overall, that states are now demanding greater allocation of resources from the center, and also because their avenue of revenue generation for the states have decreased, and hence particularly post GST regime they are very much dependent on the states. That's why. So basically states are demanding greater fiscal autonomy, greater financial autonomy for their own survival. So in that sense you can also see this topic from a center state financial relationship, cooperative federalism, or there is conflict between center and states, cooperative federalism resulting into conflict. Okay, so it says, since this article talks about horizontal devolution of funds, it says horizontal devolution of finance refers to the distribution of tax revenue among different states within a country, ensuring a fair and equitable allocation based on various criteria. Now one of the criteria is referred as income distance, right? Income distance refers to per capita income of a state, and the Finance Commission has come up with a formula, simple formula, saying that see, a state whose per capita income is less will receive more funds. Very equitable sharing formula, I would say. And then it says this process of horizontal devolution is typically overseen by Finance Commission, which assesses the needs and fiscal capacities of each state and recommends how to divide the divisible pool of taxes accordingly. And hence the existing formula of for horizontal devolution with a heavy weightage given to population and income distance is seen by economically progressive southern states as penalty for performance and responsible governance. Now see, the paradox here is that Finance Commission said that those states who are economically better, who are economically well off, then on that basis their share of revenue should reduce, see, comparatively as compared to other states. Some of the southern states are saying that why this should happen, just because we are implementing the policy well, just because we are good on various parameters, indicators, why should we suffer in terms of sharing of this divisible pool of tax? Why should we get lesser amount? This is what the states are saying, right? And based on this overall understanding, what we need to understand from a constitutional perspective, see, this is an ever ongoing demand of states that they want greater share from the center, but whether center will approve or not, time will only tell. But from our exam point of view, what is important? Knowing about Finance Commission, its functions, and a previous year's question which has been asked almost on the similar topic. Now, if you go through this news, exactly this is what has been highlighted here. I need not go through it, reading word by word. Based on this, just look into this question. Asked in the mains of 2021. See, 2021. It says, how have the recommendations of 14th Finance Commission of India enabled states to improve their fiscal position? Now, 16th Finance Commission has been constituted. So, it's very much possible that a question can be asked with respect to 16th Finance Commission and its mandate. What are the mandate of 16th Finance Commission? This could be asked. And here, we need to know about Finance Commission constituted under Article 280 by the President. President shall constitute a Finance Commission, and it says Parliament may by law determine the qualifications which shall be requisite for appointment as members of Commission and the manner in which they will be selected or they will be appointed. And for this purpose, this is the law, Finance Commission Miscellaneous Provisions Act 1951. Okay, this is the law for this purpose. And it determines qualifications for appointment of members and chairman of Finance Commission. So it says that the chairman of the commission shall be selected from among persons who have had experience in public affairs, and 4 other members shall be selected from among those who have been or are qualified to be appointed as judges of High Court, who have special knowledge of the finances and accounts of the government, or have had wide experience in financial matters or in administration, or have special knowledge of economics. So any of these can be appointed as members, and for chairman of Finance Commission, he must have experience in public affairs. This is what is provided under the Finance Commission Miscellaneous Provisions Act of 1951. So please remember this. The selection criteria for members of Finance Commission are not mentioned in the Constitution of India. This can be asked anytime. Disqualification. Person shall be disqualified for being appointed as member of the Finance Commission if he is of unsound mind, if he is undischarged insolvent, if he has been convicted of an offence involving moral turpitude, if he has such financial or other interest or is likely to affect his functions as a member of the Commission. And term of office of members. Every member of the Commission shall hold office for such period as may be specified in order of the President. So, this particular legislation does not provide for the period. Please note this. The Finance Commission Miscellaneous Provision Act 1951 does not specify any time period. It simply says the time period will be specified by the presidential order. It shall be eligible for reappointment, but they shall be eligible for reappointment. A person once appointed as member of Finance Commission or chairperson can be again appointed as such. And lastly, provided that he may by letter addressed to the President, resign his office. So all these are important aspects from your pre-perspective. Now, Dr. Arvind Panagaria is the chairman of 16th Finance Commission. Now the government has constituted 16th Finance Commission, and he is a professor of economics and a Jagdish Bhagwati Professor of Indian Political Economy at Columbia University. This is not important, but the fact that Dr. Panagaria is the chairman of 16th Finance Commission. Remember this. You never know, these type of questions can also be asked. Now let's talk about the functions or the duty of Finance Commission to make recommendations. So what sort of recommendations does the Finance Commission make? It says that they recommend on the principles of distribution between union and states of the net proceed of taxes. So on what principles the net proceed of tax will be shared between center and states? This is provided by Finance Commission. The principles which should govern the grants in aid of the revenues of the states out of the consolidated fund of India. Okay. What else? The measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats in the state on the basis of recommendations made by Finance Commission of the state. So, based on the recommendations of State Finance Commission, the Finance Commission constituted under Article 280, they also suggest certain measures for panchayats and municipalities. So, don't think if a question is asked in your pre that Finance Commission constituted under Article 280 does not suggest anything with respect to local bodies or panchayats and municipalities, don't think that to be correct. They do suggest that too based on the recommendation of State Finance Commission. The measures needed to augment consolidated fund of a state to supplement the resources of municipalities in the state on the basis of recommendations of Finance Commission, State Finance Commission. Any other matter referred to the Commission by the President in sound interest of sound finance, and the Commission shall determine their procedure and shall have such powers in the performance of functions as Parliament may by law confer. So whatever Parliament confers on them, they shall have the power, and recommendations of the Finance Commission shall be laid before each house of the Parliament by the President. So this is what has been highlighted here. Some of these are important from your prelims, but this part, the duties mentioned in the Constitution under Article 280 Clause 3, all of these A, B, C, B, B, C and D, all of these are important duties of Finance Commission. Basically, these are the principles on which it suggests allocation of resources to states and also panchayats and municipalities. Now, talking about this question asked in your mains examination, that recommendations of 14th Finance Commission, whether they have enabled states to improve their fiscal position. They did try, and let's go through the provisions. So what were the suggestions of 14th Finance Commission? Increasing vertical distribution of taxes from 32 to 42% in the form of untied grants. That is, provide them the amount without specifying the conditionality that you have to spend on this, you have to spend on, let's say, infrastructure, or you have to spend on water, etc. Providing broader parameters for horizontal distribution of taxes based on 1971 census, changes in population since then based on also on income distance, that is per capita income, forest cover area, etc. Providing maximum weightage to income distance 50% for horizontal distribution of taxes, which was based as on per capita income of states, ensuring more funds for poor states. But this is something which the southern states are protesting against. Considering states' entire revenue expenditure needs without distinguishing between plan and non-plan expenditure. Providing grants for panchayats and municipalities based on 2011 census. This was also another suggestion of the 14th Finance Commission. Ensuring basic and performance grants in the ratio of 90:10 for panchayat and 80:20 for municipalities. Creating GST compensation fund, another source of conflict between center and states. States are demanding greater compensation funds, greater GST compensation funds from the center. Providing revenue deficit grant to some states. So overall, as a part of the conclusion, this answer says, thus 14th Finance Commission has not only strengthened cooperative federalism, but also ensured greater financial autonomy and funds to states for their overall growth and development. So this is a sort of a model answer. I'm sure you can write a better answer, but at least these are some of the important points which you must highlight while addressing this particular question. So that's why I had taken this particular news, and the remaining two news are mostly from the perspective of your prelims examination. So it says Election Commission of India upgrades mechanism for index cards on electoral data, replaces manual entry. And by leveraging automation and data integration, the new system ensures faster reporting according to ECI. Functions of important constitutional bodies, namely Election Commission of India and its various functions. Now see, when we talk about ECI, there is a three term which is actually associated with it. Superintendence, direction and control. These provided under, talking about ECI, these provided under Article 324 provides wide powers to the Election Commission. And along with this, along with the Constitution, the Representation of People Act 1950 and Representation of People Act 1951, along with various rules such as conduct of election rules or symbols order, whereby the Election Commission has power to recognize political parties, give them national status, state the status of being a national party or a state party, or recognized RUPPs. All of these powers flows from Article 324 of the Constitution of India, from these three words: superintendence, direction and control. All of these are vested in the Election Commission for conduct of election, and for this purpose a lot of powers are vested under the Representation of People Act 1950, Representation of People Act 1951, and various rules including conduct of election rules. This is an important point, and based on these conduct of election rules, lot of changes are made on a day-to-day basis with respect to conduct of elections. Okay, as the name suggests. So it says that the Election Commission of India said that it had upgraded mechanism for generating index cards, making it more technologically driven. These cards is a non-statutory, see this word, it's non-statutory, means its origin does not come from a statute, does not come from a legislation of the parliament. Post-election statistical reporting format that promotes accessibility of election related data at constituency level for different stakeholders such as researchers, members from academics, journalists, normal public, etc. And on this note, see, it's important to know that this index card is a same point, non-statutory post-election statistical reporting format development suo motu, that is by the Election Commission itself, under broad powers to it under Article 324, to promote accessibility of election related data at constituency level for all stakeholders including researchers, academia, members of academics, policy makers, journalists, general public, etc. And says technology driven system to generate these index cards and various statistical reports after conduct of elections. This upgraded mechanism replaces the traditional manual methods which were often time consuming and prone to delays. By leveraging automation and data integration, the new system ensures faster reporting. So you see, all of these have been provided with respect to these index cards, and this index card forms the foundation for generating about 35 statistical reports for Lok Sabha and 14 for state assembly elections. So it will provide statistics or data or report for both Lok Sabha elections and state assembly elections as well. And these reports cover variables like state constituency wise elector details, member of polling stations, state and constituency wise voter turnout, participation of women electors, performance of national or state parties and RUPPs, registered unrecognized political parties. These are recognized under the Election Commission symbols order. Winning candidates analysis, detailed constituency wise results and summary data reports. So basically these will be technology driven, all these data will be collected through technology, and it will help to collect these data in a faster manner because now it will not be done in a manual way. Now in relation to this, earlier there was this news. This is the news of, let's see, May 24, 2024. So basically last year news. But this is relevant. It says Supreme Court denies interim order on booth-wise voter data. Court says that it does not want to divert attention of the Election Commission in the middle of a poll. Application to publish of turnout data in Form 17C has already been sought in a petition pending since 2019. So you need to know about Form 17A and Form 17C. So it says, according to the Conduct of Election Rules 1961, the Election Commission has to maintain two forms, 17A and 17C. So Form 17A has details of every voter who comes into a polling booth and casts their vote. And 17C is an account of all the votes recorded. And currently ECI does not provide public access to Form 17C, stating that, that is, account of all votes recorded, stating that it is meant only for candidates and their polling agents. Okay, so you need to know about 17A and 17C. So let's see whether there would in future are there any changes in Form 17A and 17C. I'm sure articles would appear. Based on our discussion, this becomes your practice question. Consider the following statements. First, the index cards rolled by the EC, Election Commission, statutory in nature, will form the foundation for generating about statistical reports for Lok Sabha election but not for assembly elections. Incorrect, because it is for both Lok Sabha and assembly elections, and it is a non-statutory report, not a statutory report. Okay, please remember this. Second, according to the Conduct of Election Rule 1961, Election Commission maintains details of every voter who has cast their vote in Form 17C, whereas Form 17A captures account of all votes recorded. Let's quickly go through 17A. 17A say it has details of every voter who comes to cast their vote. Hence, this is also incorrect. Which of the statements given above are correct? Neither one nor two. So I hope through this practice question, you understand the importance of current developments. And lastly, this news on start of census, how India conducts its census and what is new in 2027. As I've told you, two important things are associated with is that this is important from the perspective of delimitation, which will take place post 2026, and reservation of seats for women in Lok Sabha, State Assembly and the State Assembly of National Capital Territory of Delhi. This is what is important. Another important aspect is that exercise of census is a statutory exercise, and Ministry of Home Affairs has notified under Section 3 of Census Act 1948. So it is a statutory exercise conducted under a legislation of Parliament, that is Census Act 1948, and says the government has formally announced 16th Census of India will take place in two phases, house listing phase and then enumeration phase, with reference to dates set as March 1st, 2027 for most of the country and October 1st, 2026 for snowbound and remote regions such as Ladakh, Jammu and Kashmir, Himachal Pradesh and Uttarakhand. This census marks a significant milestone because it will also enumerate caste data. This was last done in 1931. So this census exercise is more than the process, it has more meaning because of its associated events. That's why this topic is important. Now, conduct of census in two phases. Phase 1, house listing operation. The housing conditions, assets and amenities of each household will be collected. In second phase, population enumeration. The demographic features will be recorded, socio-economic aspects, cultural and other details of every person in each household will be collected. And in census, caste enumeration will also be done after 1931. Please remember this. Now let's come to the associated part. Constitution 106th Amendment Act 2023. It talks about reservation of seats for women takes effect. Let's go through the provision very carefully. I'm just reading it out. Notwithstanding anything contained in the foregoing part of the Constitution, the provisions of the Constitution relating to reservations of seats for women in the House of the People, the Legislative Assembly of a state and the Legislative Assembly of National Capital Territory of Delhi shall come into effect after an exercise of delimitation is undertaken for this purpose after the relevant figures for the first census taken after commencement of this Constitution 106th Amendment. So when will this reservation be given? After delimitation. After delimitation. After exercise of delimitation is taken, anyways, which is to happen either in 26 or after 26, after relevant figures for the first census have been taken, relevant figures for the census have been taken after commencement of Constitution 106th Amendment. Okay, have been published and shall cease to have effect. So this reservation for women has expiry period also. So when does it come into effect? After the census is taken, after the Constitution 106th Amendment comes into effect. So basically the 2027 census is what? After this reservation for women in Lok Sabha and State Assembly could be given. and this will have an expiry period of 15 years, have been published and shall cease to have effect on the expiration of period of 15 years from such commencement. So it's not like that this reservation will be for infinity. It is for a period of 15 years from that commencement. But conduct census exercise is an important criteria. That is the point here. And second point, with respect to reservation, it says, as nearly as may be, one third of the total number of seats reserved under Article 330 shall be reserved for women belonging to scheduled caste or the scheduled tribe. Okay. And as nearly as may be, one third, including number of seats reserved for women belonging to scheduled caste and scheduled tribes, of the total number of seats to be filled by direct election to the House of the People shall be reserved for women. And same criteria is provided for reservation of seats for women in legislative assemblies. See, as nearly as may be, one third of the total number of seats reserved under clause 3 of Article 332 shall be reserved for women belonging to scheduled caste or scheduled tribes, and here subcategorization as well. So based on this was your prelims question asked in 2024. I am sure after our discussion you will be able to solve this question. It says, consider the following statements regarding Nari Shakti Vandan Adhiniyam. First, provisions will come into effect from 18th Lok Sabha. No, 18th Lok Sabha was June of 2024. So it will not commence after that. It will commence when? After delimitation takes place post the census. After the census which takes place after commencement of Constitution 106th Amendment. So here we are talking about 2027 or thereafter. Hence this would be incorrect. This will be in force for 15 years after becoming an act. Correct? This is incorrect. First is incorrect, second is correct. And third, there are provisions for reservation of seats for scheduled caste women within the quota reserved for scheduled caste. Yes, which we just saw. So even if we exclude first, then this is eliminated, this is eliminated, this is eliminated. Correct answer is C, 2 and 3 only. So you see, at times even related information associated with a current event, current development becomes important. That's why we need to go through these important current developments in different sections. So these were the important topics which were needed to be covered from the section of polity, and from next week onwards we'll again similarly cover important news which will appear consequently in the news relevant from your exam perspective. That's the idea, that you understand the topic, you understand the concepts, and you also go through some of the practice questions, either prelims or mains. Now this initiation, this step to discuss weekly current affairs classes is a part of the foundation course at PMFIS. Now we are starting this foundation course tomorrow. All of you who wish to join the foundation course, please call on this particular number. As you can see, if you want to note down, please note this number, 9211591415. Okay, and if you want to take individual courses also, there is a room for flexibility. Let's say someone do not want to take the entire foundation, then you have flexibility. You can take economy, you can take science and tech, you can take both science and tech and economy, or you can take science and tech, economy and environment, or polity, whatever way you like. We have complete flexibility for that purpose. So I hope you understand the initiative. I hope you appreciate the initiative, because we are putting a lot of effort and a sincere effort for you students who are sincere and who are very much committed to clear this examination. We are committed towards you, and the idea is to give you correct information. The idea is to not give you unnecessary noise. The idea is to provide you or guide you in the right direction. I hope whatever topics we discussed today, you will have a better understanding of those topics, not only with respect to those topics, but related topics which appear in the news later. Thank you very much for watching the Magnum Weekly Current Affairs for the section of Polity. Stay tuned for other subjects as well. Thank you.